This is the brief on international commercial arbitration. Based on the Philippine ADR Act and UN model law, we're exploring how global businesses bypass traditional courtrooms to resolve complex disputes by literally writing their own rules. First, how do you even get started? Well, it's all about party autonomy. Think of it as DIY justice for businesses. Instead of walking into a regular court, you build your own private process. You decide the rules, the language, and exactly who sits on your arbitral tribunal, whether that's a sole arbitrator or a whole panel. If parties hit a wall and can't agree on who to hire, a default appointing authority, like the national president of the Integrated Bar of the Philippines, just steps in to pick for them. Second, once you've built this private court, it operates completely independently. The golden rule here? Regular government courts absolutely must stay out of the way. The arbitral tribunal is so powerful, it actually rules on its own jurisdiction. But wait, what if someone tries to hide evidence or destroy property before the tribunal decides? Well, that's the rare exception where regular courts step in, solely to offer interim measures of protection or to help subpoena witnesses. Finally, we reach the end of the line, the arbitral award. This final decision is incredibly tough to overturn. You can't just appeal because you hate the outcome. To legally vacate or set aside an award, you've got to prove extreme circumstances, like outright fraud, corruption, or that the tribunal blatantly exceeded its powers. Ultimately, international commercial arbitration trades the endless appeals of traditional courts for a highly customizable, strictly final path to resolving massive business disputes.